please rise. The Court of Appeals is now in session. Please be seated.
Welcome to the Court of Appeals. We're sorry for the delay. Usually our technology is a little bit smoother, but it's delayed us a little bit. We also apologize for the smoke smell, but I can confirm to you that it's not this building. It is apparently a restaurant down the street is on fire. So we do not anticipate any imminent evacuation, so that's all good. We have a single matter up for oral argument this morning, the case of Meraz-Zamorano and the state of Utah. If counsel would state their appearances, please.
Natalie Scavine for Mr. Meraz-Zamorano.
Wasong Doucette for the state of Utah.
Very good, and I see 12 minutes on the clock, so you're reserving 3, is that right?
That's right.
I don't think you need any explanation of what to do, because you're both frequent flyers here, and so we'll just proceed. I just wanted to make sure I don't see Judge Forrester on the screen. I want to make sure there's not an issue there before we get started.
You don't see me?
I don't, do you see her?
No, but I just heard you.
I'm here.
Okay, can you see counsel?
I can see the courtroom and I can see you.
The problem is without the visual, we're not going to know if you're raising your hand. So we can either proceed and you can just rudely interrupt us, or we can wait a minute to see if we can get it up. Do we know?
Wait, oh. Am I there?
Now you're here. Awesome.
Okay.
You may proceed. And just so you know, because she's muted and coughing, as you can see, the reason Judge Christian Forster is online is because she's a little bit under the weather. And we appreciate her not sharing that with any of us. So anyway, you may proceed.
Thank you. May it please the court, Natalie Scavine for the defendant, Mr. Meraz-Zamorano. I'd like to start with the jury selection issue. The state's position is that there is no claim in Utah for losing peremptory challenges to prevent trying a case to a biased jury. The state gets there by arguing that Turner forecloses a claim under the Utah Rules of Criminal Procedure, leaving only a potential Sixth Amendment claim of juror bias. First, Turner did not rule on the issue of losing peremptory challenges to remove biased jurors at all. It was limited to addressing preservation for a constitutional claim of juror bias. And still, Turner suggests that a violation of the Utah Rules of Criminal Procedure in selecting the jury is a claim in Utah, and that peremptory challenges are important.
But you'd still need to show prejudice, right?
You would still need to show prejudice. And in this case, we've done that by showing that all 6 were lost, that there are indications that the jury in this case ended up deciding the case on something other than the facts before them, on the way that this was the kind of case where the evidence was not overwhelming, and that kind of gets to the distinction between a case like Saunders and a case like Walk. Saunders was a child sex case with no medical evidence, no physical evidence. Allegations arose during an acrimonious divorce, and the loss of a peremptory challenge was one error that accumulated with other errors to result in reversal. And then on the other hand, we have a case like Walk, where it was the mother was the victim, the defendant was her son. The mother ended up in the hospital. The defendant admitted to assaulting her. There were other witnesses that saw it. In a case like that, the loss of a single peremptory challenge is very unlikely to be prejudicial. This case, Mr. Meraz-Zamorano's case, is more like Saunders, with cumulative error, with a case that could have gone either way depending on the composition of the jury.
Can I unpack your argument just slightly? Let's say, just hypothetically for a moment, that we didn't have the verdict form issue, that was absent from your analysis. What would the effect be? Because I think what you're arguing is where all 6, I'm sorry, the smoke's making me want to sneeze, where you're having to expend all 6 preemptories, that in and of itself is prejudice, that you don't necessarily need the evidence of the jury verdict form having gone wrong.
I think It could be, and we would still have a good argument in this case if we didn't have that. Again, because it was all 6 peremptory challenges in a case with a sensitive issue that depended on credibility where the composition of the jury was likely to matter. And then on top of that, we've argued cumulative error with the trial errors as well.
An additional question I had is, I guess one of the stumbling points for me is if we take an alternative universe where the court grants all 6 challenges, so you have 6 completely different jurors on this panel, you still would have this verdict form issue, and if the verdict form issue is more, I guess the fault for that is more assignable to the judicial officers in the room, the lawyers and the judge, how does that give us a likelihood of a different result?
So the question is if all we had was the verdict form
Right,
and a different
right.
panel of jurors?
Well, I'm saying it, what likelihood is there where we have a verdict form that's listing an aggravating factor that shouldn't be there, but it's on the jury form, and now we have these lay folks sitting there, and there's a box, and they feel like I gotta check it or do something with it. What is the likelihood of a different result with 6 different people than the ones that you're saying should have been excused for cause?
Well, our argument is that the fact that these jurors checked a box finding an aggravator that the prosecution even said in closing argument did not happen is an indication of bias. It's an indication that they were basing this on something other than the facts presented, and it could have been a mistake based on the facts that was impacted by bias. But either way, it's just an indication of that. So it shows how that initial error was prejudicial. And so our argument is that if there had been a different panel of jurors, it's unlikely they would have made this mistake, that the verdict form would have been impacted by bias at all. In a case where there's no problem in jury selection and we end up with a verdict that looks like this, we're gonna have to find a different way to try to argue there was a problem. But in this case, our argument is that because the defense didn't get a hand in selecting the jury, we ended up with a jury that came up with this verdict form that indicated bias.
Can I articulate that back just to make sure that I'm getting it all? That if you had not had to use your 6 peremptories on those that you feel should have been stricken for cause, you would have, the likelihood is that those peremptories would have landed on at least 1 or 2 jurors who were biased, but we don't know who they are in this record. And that not only would they not have mistakenly marked the box that the state said doesn't apply, that then presumably they would have also made a different decision on one of the other charges or aggravators.
Right, that there's a reasonable likelihood that a jury that didn't have a bias could have come out the other way on the other charges, right?
And all you need is 1 charge or 1 aggravator for it to be different.
Right. For it to be more favorable.
Can I ask a question about that in the sense of if you didn't use all of your peremptories on those that you argue should have been stricken for cause, which didn't allow you to use those peremptories tactically, right? Like that's what Turner tells us, that peremptories are, party can use those tactically. How would you, I'm still struggling with how you prove that there was a biased juror. I understand the verdict form and that credibility was an issue here. But if a juror hasn't been flagged in voir dire as somebody who may be biased or have issues, I guess I'm just struggling with what level of proof? And in this case, is it just the verdict form and the credibility issues?
It's yes, the verdict form, it's the strength of the evidence or the lack of the strength of the evidence in the case. It's the fact that all 6 were lost, it's combination with the other trial errors. And then I would just point to the way that our rules and our case law talk about the importance of peremptory challenges and how Turner recognized that counsel could reasonably think that a juror who did not have a stated bias was the more dangerous juror and that would be a reasonable position to take. And that echoes a line from the dissent in Ross v. Oklahoma, which said that it cannot seriously be questioned that the loss of a peremptory challenge vis-a-vis the prosecution burdens the defense. I also think about the way that we spend more than twice as long on jury selection so that both parties get their peremptory challenges. If we need 8 jurors, each side gets 4 peremptory challenges. We spend a lot of time and resources making sure that we're following this rule. It's important.
I think that the language from our case law that I've seen that best helps you, and I haven't heard you quote it, so I'd like you to have an opportunity to comment on it, is from State versus Holm, where jurors, where the defense was not able to ask as many questions as they wanted, and this court found that, yes, the defense should have been able to ask additional questions about people who had been in serious car accidents. And then under the prejudice prong, we said, in light of the dearth of information available to Holm on these issues, his right to the informed exercise of peremptory challenges was significantly impaired, and we reversed. It seems like that has to be the kind of language that we'd have to latch onto, that here, if you have to use all 6 to get the for cause people, your right to use those in other ways was significantly impaired. Would that be your argument, and do you have any other comments on that?
I think that we have cited Holm. I think that language is what is needed to sort of reconcile the language in Menzies and Walk about showing that you have to show a biased juror with the fact that it is not the case that the only way to show an error in the jury selection process is to show that a biased juror sat on the case, that there's more flexibility in our prejudice standard. I think that is a good standard for prejudice, and we've met that standard. And we've also argued we've met the even higher standard of showing a reasonable likelihood of a more favorable outcome absent the error. I think under both standards, there's prejudice here.
Can we just take it one step? What's the ultimate outcome of this, though? Aren't you saying that if you have to use all of the peremptory challenges on people on panel members who have expressed some sort of bias, but they are not removed for cause or not stricken for cause, anytime a verdict goes against you, you have a reason to challenge it?
Well,
and is that the outcome that you're asking for?
if you lose all 6 peremptory challenges to jurors who should have been struck for cause, it's likely that there should be a reversal in the case. And Turner said even if there's one, biased juror that sits on the panel, that's structural error, that's automatic reversal. So it's going to be a lot harder to show prejudice if you don't have a biased juror on the panel and you're arguing that you've lost peremptory challenges. And that's what the Menzies concurrence said, is that this is not going to be easy. And if you lose a single peremptory challenge to striking a juror that should have been struck for cause, it seems very unlikely that you're going to be able to show prejudice. And again, in this case, we have lost all 6. It's a case where the evidence was not overwhelming, where we have other trial errors, and where we have this verdict form that indicates that there was a biased jury.
In your briefing, you don't, as you walk through the 6 jurors that you have issues with, you don't tackle them in numerical order. Are we safe to assume then that the order in which you tackle them is the, that the first one you've addressed you think is the most egregious and so forth?
I'm gonna come back to this on rebuttal because I think I did it in the order that defense counsel challenged them, but I'm not 100% sure where the order came from.
Okay.
I don't see any other questions. You'll have your full
Thank
rebuttal
you.
time.
May it please the court, Wasong Doucette for the state of Utah. I welcome any of the court's questions on any of the issues, but I will begin with the jury issue. I think the court makes a good point about kind of, well, what exactly is the prejudice to the defendant here? Their prejudice here is solely the loss of these peremptories, which they voluntarily chose to use to cure the jury of any potential bias. Defendant can't now come on appeal and say, oh, I lost those peremptories because the court didn't grant my for-cause challenges. Turner says that defendant gets to use the peremptories however they want, and this is how defendant chose to use them here. And the idea.
So what you're saying is if you want to claim error on appeal, you need to make a calculated, or a rather risky calculation, in their case. For example, they could have said, well, we think the judge was wrong on all 6, but we're gonna let one of them sit. Even though we think they're biased, if we really wanna preserve this issue for appeal, we have to let them sit. And you would agree that if they had let one of the 6 sit, and we were to conclude that they should have been dismissed for cause, then they would have a basis for reversal, no?
Yes, because then they would have shown
That a
would have.
biased juror said.
Correct.
Right.
Well,
So do
there's.
they need, that just seems to put them in a somewhat untenable position that you're saying that the clear path for winning on appeal is to recognize the error, and let it ride, thinking that now you've got, an appealable issue in your pocket. That seems to be, kind of overwhelmingly risky. Because if you're wrong on the call, you know what I'm saying? You've got somebody who you truly believe is biased, but if 3 appellate judges don't think it quite crossed the line to a for-cause reversal, you've then subjected your client to what you believe is a biased juror. Do you see the dilemma?
Yes, but unfortunately, that's kind of what Turner lays out, is, well, and Turner's Utah Supreme Court case law, so if defendant makes the strategic decision, well, I'm gonna have to let the one the one juror I challenged for cause, because I think another juror has a hidden bias, and I need to use my peremptory on them, then that's what Turner says the defendant gets to do. But just because defendant on appeal can then show that, well, this for-cause challenge juror sat, that doesn't mean he's won, because he still has to, this court still has to decide that if that juror actually had the bias that he was being challenged for.
Isn't that wrapped up in the deciding if the for-cause challenge should have been granted?
Yes, but that's also under a deferential standard of abuse of discretion by the trial court. So just because maybe this court disagrees that the bias existed, still has to defer to the trial court, because the trial court's in that position of seeing the body language, hearing the tone, and on appeal all we have is, this record where we can, make up things in our head of what was said, but the trial court is the one who ultimately hears how it was said and how the jury kind of responded to everything.
How would you address the language that I quoted from Holm, about that if the right to the informed exercise of peremptory challenges was significantly impaired, that would merit a finding of prejudice? And if you have to use all 6 of your peremptories to catch the ones you think should have been for cause, doesn't that significantly impair your informed use of your peremptories?
Well, there's a distinction, and I think it's something that the state wants to clear up, is that we're not saying that there is no there's never going to be a loss of peremptory claim. There are two other situations where there will be a loss of peremptory claim, which is what Holmes presents, which is where the defendant doesn't get to fully question the jurors because the trial court has restricted them. That is a different claim than what's being presented here on appeal. And then we also have.
Factually, I see the distinction you're making, that in the one instance, I didn't get to ask the questions I wanted. And here, I didn't get to strike the people that we asked enough questions that we know. But if the legal standard that comes out of Holmes was your use of your peremptories significantly impaired, does that factual distinction make a difference if either way it's significantly impaired your use of peremptories?
Well, yes, because in this case, there's nothing that significantly impaired defendant's choices other than that's how he decided to, or decided on how the jury should be impaneled. There's nothing here, everything here was voluntary from defense counsel and defendant, because Turner there's no cure or waive rule. Nothing else limits how defendant gets to use his peremptories.
Wouldn't it be a fair argument from their side, though, to say that it's almost a sliding scale of ever diminishing free will? That if there's one juror that you have to use a peremptory that should have been challenged for cause, that still leaves you 5 over here. But where they're claiming that all 6 of their peremptories should have been removed for cause, is that really a choice then? Do you see how they're basically boxed in by the trial court? Now it's not really a free will when the trial court, let's assume for a moment that all 6 are bad calls, that not only would we conclude that they should have been stricken for cause, but it exceeded the discretion of the trial court, so they're reversible in the determination of letting them sit. And since they had to use all 6, where's the free choice in that?
The free choice in that still exists, that they can let them sit. They can use their peremptories on other jurors. That's the free choice, and the abandonment of the cure or waive rule. And I understand that is a risky decision for defense counsel to make and defendant to make on appeal, but that's the choice that they are given under Turner, and Turner doesn't leave really any wiggle room in there to say, well, if defendant decides to use all his peremptories to strike these 4 caused denial or denied jurors, then he automatically, because that's what defendant is arguing, he automatically gets a reversal.
On these 6 jurors, do you agree with, how many of them would you agree that their initial answers raised a presumption of bias? Do you agree that any number of those 6, their initial answers raised a presumption?
Well, I know we didn't present that argument, but I think they do, and how they responded. But I think the further questioning goes on, then the trial court is satisfied, and the satisfaction. So
as to all 6, you would acknowledge that the initial responses raised a presumption, but then as to all 6, you would say that their further answers resolved that presumption?
Yes.
For all 6 of them?
Yes.
Even if the only thing that ameliorated the concern was their self-representation, that despite what I just said, I think I can be fair, is you think that's enough under the law?
Well, that wasn't the only responses that they gave. They did go into detail about, the situation, how much knowledge they had about what gave them the presumption of bias, and, the trial court gets to consider all of that. It just happened that that's how they ended their responses, because the trial court goes, well, based on all of that, which trial court now has information on, well, do you think you can remain impartial? And which they all responded yes. So it's not just the affirmative kind of, yes, I will remain impartial. There are details in there that the trial court has to assess based on more than just their response, or their affirmative response.
I wanted to point out that we sort of dealt with this issue, this sort of tactical decision that's at issue here, in a case earlier that was issued earlier this year, State versus Taylor. And in footnote 3, we recognized that because a defendant is not required to use their challenges in a particular way, it does leave the door open for tactical use, and which even leaves the door open, as Judge Mortensen pointed out, that if you leave a biased juror on your panel, excuse me, that is a claim that you can raise on appeal. And I don't know, I just wanted to point out that case. We dealt with this issue.
Well, I agree, that leaves the door open for a preserved claim on appeal, but that's kind of the problem we have here, is there is no preserved claim to review because there is no biased juror that sat. And the kind of idea that the verdict form is now going to inform that essentially one or all 6 of the jury that was impaneled is biased kind of is illogical, because defendant would have has at the beginning of trial or before trial, defendant has no idea that the jurors are going to make this mistake on the verdict form, and how that informs how he was going to use his preemptories to begin with. It's kind of taking an odd way to say, well, I was prejudiced by what could have been a mistake or what defendant claims is alleged bias. And kind of the problem we have here is, well, we have to work under the presumption of regularity and at the trial level. And if we're going to be basing an argument based on the assumption of bias or the assumption of mistake, kind of we have to go with regularity, and it has to go to, well, the jury made a mistake. And yes.
If would the case here be different if we had on the record defense counsel saying, to the trial court, I'd just like to put on the record, and then says, we would have exercised our peremptories in this other way. Juror seat number 10 was a young college student who we don't think would have paid attention, or and identified who they would have used their peremptories on otherwise and reasons for it. Would we be in any different circumstance in analyzing this under prejudice?
I think we would be a little bit different circumstance, but it still goes to, well, what is on the record to show the bias? Because even though defense counsel may bring up, like, well, I would have used my preemptor on this other person and this is the reason, perhaps the trial court would have taken the further step and then gone and questioned the juror to flesh out if there was an actual bias. So, I mean,
But that would assume that you've got to show, actually, there weren't just 6 that should have been stricken for cause. There were 7, and if we'd have had one more peremptory, we'd have used it there. Or, I don't know if that makes sense. Your response suggests that to show prejudice, you really do have to show a specific juror with bias, and that's the only way.
well, that's what it says under Taylor, is to prevail on a juror bias claim, the defendant has to show actual bias. So Taylor kind of lays out, well, this is what you need to do to preserve your juror bias claim, and this is the prejudice that you have to show to prevail, and which is that the defendant was actually biased. So even though defense counsel may say, I want to use my preemptor on this, on appeal, defendant still has to show what that actual bias is, and has to show that it was there.
And if that has to be showing a specific juror who shouldn't have sat, it sounds to me like you're saying that the decision in Holm was wrong, that significant impairment of peremptories really shouldn't be a rule for showing prejudice, that you have to show a specific juror sat that was biased.
No, I think that's a different, and I know it seems odd, it is a bit more of a different claim, because the loss of peremptory would be under the Rule 18, which lays out how many peremptories everyone gets, and if the defendant under that rule doesn't get to exercise their peremptories intelligently, because the trial court has limited that, in my opinion, that is a different claim.
Okay.
That is a separate loss of preemptory claim than this juror bias claim. So this juror bias claim, where the loss of a preemptory doesn't apply as a harm anymore because of Turner, and then the separate loss of preemptory claim for under Holmes, or Holm.
I don't see any other questions.
Okay.
Thank you.
We would ask the court to affirm.
I didn't want to rob you of your 10 seconds, but it looked like you were done. All right.
Thank you, Natalie Scubine, again for Mr. Meraz-Zamorano. I checked, we did argue in the order that defense counsel at trial had used the peremptory challenges, so that was the reason for the order in the argument section.
If that's the answer about the brief, then I'd want to give you a chance to say, here, maybe here are the ones that we think are most clearly biased, even after the follow-up questioning, or are you willing to do that, or do you say, no, they're all just biased?
Well, we'd argue that they are all biased, the state hasn't argued otherwise. And one thing that's kind of interesting about it is that when I look at the list, I think that the juror that we struck fifth, who said the thing about, I'm surprised how many people aren't prosecuted and how common this is, that stood out to me. But it seems like for defense counsel and, maybe in consultation with the client, sitting there in the room, it might have felt differently. There might have been something about the other jurors that doesn't appear on the record that was more concerning even than that one. So we'd argue that all of them should have been struck for cause. And there is a part in the record, at record 1302, where defense counsel says if they had granted the motions to strike, the defense counsel would have removed other jurors and said because we had to strike those, we're now using, or because we didn't strike them for cause, we're now using our peremptories on them and leaving others. So that defense counsel did make that clear. And then later on, defense counsel raised this really at every opportunity. At record 1340, the court actually says to defense counsel, I don't know why you keep bringing this up. And then another point I wanted to make was that when we're talking about each individual juror or each individual potential juror, one of the problems was that the court seemed to be using the wrong standard, which would have infected all of the rulings on that. The court said they were not unshaken in their conviction, that they could not be fair and impartial. So it wasn't a finding specifically that the court was convinced that they can and will act fairly. So that was a problem for all six. And I think that's all I have. If the court has no more questions, we'd ask the court to reverse.
Okay. Well, we appreciate your arguments this morning, and especially we appreciate the briefing in this matter. We'll take it under advisement and issue an opinion in due course. And with that, we will be adjourned.
All rise.